start with explaining the difference between the Bill of Rights and the Constitution,
Okay.
or how they work together. Just act like I'm some red coat who's run off with his tea, who's come back and he said, you know what can we learn from you? What happened after we sailed back to England?
All right. So I think what I'd like to try and do is challenge your perceptions of the Constitution. Maybe you already have these perceptions and understand this to be the way to view the Constitution, but I don't think most people do right now.
Shall I give you my two simple views of the Constitution?
Sure, please do.
My very first simple view is that I'm jealous we don't have a constitution in the UK. I know we have the Magna. Someone's going to comment on YouTube. We got the Magna Carta. We don't have something which people refer to. We don't have politicians standing up in Parliament saying, but in the Constitution, or this is unconstitutional. We don't have the press saying this is unconstitutional. We don't have lawyers saying it's unconstitutional. So I'm jealous that we don't have something there that we refer to that is a framework for the kind of freedoms that we want within our country. That's the second thing. The other simple view I have is, it seems to be hard to change. Seems to be, feels like some bits need to be updated. You know, we're a few hundred years since the Constitution was written and established.
Yeah, and that's a valid viewpoint, and a lot of Americans share that viewpoint. Okay. Absolutely, and a lot of depending on how you interpret the Constitution, yes, I mean, that is a valid viewpoint. Now, there's certain ways of looking at the Constitution that give you more flexibility with the words, and that way of interpreting the Constitution has fallen out of vogue in the last probably 40 years, in favor of strict textualism and original intent. What did it mean at the founding, and if it thus we can't have anything different now. That's not, I think people misunderstand what originalism really is. Originalism is, the text is fixed, the meaning was fixed at the founding, but that doesn't mean that meaning can't apply to new technologies and new societal situations. We just have to understand, what those words conveyed at the time, and then apply that meaning forward to new technologies. And you get examples like, Justice Gorsuch, one of the new justices, wrote a book, and then there were some excerpts in a magazine, going through some examples like cruel and unusual punishment, the Eighth Amendment. Obviously, lasers didn't exist at the time, but if you were going to, blast somebody with a laser, that would be cruel and unusual, right? It doesn't, you can adapt with the new technologies, speech. We'll come back to this perhaps later in the talk. Speech can be code. It can be code. That's right. It can be something on the internet that, the founders never even dreamed of. So, but going back to, challenging of you, your view, there's 2 points. One is the Constitution is, leaving apart the Bill of Rights for now, the Constitution sets the framework for everything that the federal government can do. Meaning if it's not in that document, the federal government doesn't have the power to do it. So it is powers that the people conferred on the federal government. You have to find, so the first question should always be when a government takes any action, like, how are you able to do that? Show me in the Constitution government where it says you have the power to do that. Okay, so that's the first, way to view it. It's a list of permissions that the people have given the government, right? To check against tyranny, to give, to make sure that the government is very constrained in what it can do. It's very much like cryptography. That's the analogy I like to use with cryptography now. Is cryptography gives you the ability to grant permissions to other people and protect your privacy, and thus constrain tyranny from the government or from big tech or whoever is spying on you at this moment. So the Constitution's like that. It's a list of permissions. The Bill of Rights is not the source of your human rights. The Bill of Rights is, again, another list of rights that the founders found important, but also a description of the ways in which the government is allowed to act vis-a-vis these rights, which are unalienable, inherent, fundamental, right? So there was a debate, and this will get into the difference between the Bill of Rights and the Constitution and a little bit of the history. There were two groups that were fighting over the Constitution once it had been hammered out in the convention. You had the Federalists, who were, strong central government, who were, approved of the Constitution as it was. And you had the Anti-Federalists, who wanted to keep things mostly the way they were, with the states being the primary governments, and kind of what we had going on was like a League of Nations type thing with the states. No real strong overseeing government. And one of the very valid anti-federalist arguments against the Constitution was there is no Bill of Rights in here. The Virginia had passed a Bill of Rights before the Declaration of Independence. It was, Thomas Jefferson used it kind of to draft the Declaration. And Massachusetts passed one like 1780. And so this was not an unknown phenomenon to list out, the rights that people have. The counter argument to that, which I also find very compelling, and we're kind of seeing the ramifications play out now today. The Federalists said, yes, but if we list out a bunch of rights, then that's going to be construed as the entire universe of rights that people have. And that's just not the case, right? We can't possibly list all of the freedoms that people have. And so we don't want to constrain ourselves that way through a document. And James Madison, who really, in my view, was kind of the father of the Constitution, he kind of mediated between these two sides. He wrote some of the Federalist Papers and was in favor of the Constitution. He had come to the conclusion that the previous document, the Articles of Confederation, was just inadequate, and really pushed to get a new Constitution. But he also started out with the belief that we can't enumerate these rights, otherwise we will, lock ourselves into this list of rights forever. He came around because eventually they passed the Ninth Amendment and the 10th Amendment, which the Ninth Amendment says, the enumeration of these rights shall not be construed as limiting the rights that the people retain, essentially. And the 10th Amendment was similar, but as to the states, the powers not given to the federal government and not prohibited to the states, remain with the states and the people. So they put these amendments in to clarify, like, this is not the universe of your fundamental rights. This is not the source of your, inalienable and your, your human rights. And so that was how the Anti-Federalists ultimately came on board with the Constitution and agreed to ratify it amongst the state conventions. Is this Bill of Rights was included.
What came first, the Bill of Rights or the Constitution?
Constitution. So the Constitution was actually passed, and so there was a brief period of time where the Bill of Rights was not included, because the Bill of Rights is a set of amendments. So all 10 of the first amendments were passed as one package as the Bill of Rights a few years afterwards. Yeah.
Okay. Right. Okay. And so in terms of the work you do now, when do you refer to the Constitution and when do you refer to the Bill of Rights?
So the Constitution, if you're doing criminal law, you're doing which I do not do a whole lot of. You're referring almost exclusively to the Bill of Rights. You're also referring to certain sections of the Constitution that guarantee the right to jury trial and things like that, which are not part of the Bill of Rights. That are in the main bulk of the Constitution. If you're talking about anything related to, if you're out of the criminal context and then you're talking about litigating against the government or litigating, what the government can and can't do in terms of legislation, or that's usually going to be the main bulk, the original Constitution, but not necessarily. To give you the lawyer answer, it depends.
It depends on the scenario.
Yeah.
Okay. So sometimes you refer to one, sometimes to both, sometimes the other.
That's right.
And it's all case dependent. And is a lot of the interpretation of the Constitution comes down to the precedents that have been set with specific litigation.
Yeah, that's correct. And so you have kind of this body of common law precedent that builds up over time. They kind of locks in one interpretation or another. And then you have big kind of epochal changes in that, like we've just seen with Roe versus Wade being overturned.
Yeah.
But there are other examples in history too, where there's just big epochal changes.
But the big epochal change that we've just seen now seems a very political change. But has it always been that way? Is it?
I'm a little cynical, and I'm of the belief it's always been.
It's always been political.
I think our view in the States of the Supreme Court as a ultimate arbiter of legal truth that stands above the political fray is almost something that kind of came about, in the civil rights era, the 60s, the 70s. And maybe it existed in the past before, but there's always been gamesmanship. There's always been politics involved. I mean, I'll give you a good example that's relevant to money and Bitcoin. The biggest case of the 20th century, if you just go by, press coverage, was actually in the 30s, and it had to do with the federal government's attack on gold. And you don't learn about this case in law school, and you don't learn about it in American history.
Is that the gold Executive Order 2106?
So it was related to that whole package that FDR was essentially that whole policy he was pursuing. And the federal government passed laws saying, any contract that has a gold clause in it, which was a clause that said, if you owe me X amount of dollars, I want it repaid, and I have the option to get repaid in gold, the gold equivalent of whatever it was at the time. And it was an inflation hedge, right? And it was, these were clauses that existed since, they always existed, but they really came into being after the Civil War, when you had, you had this big fight over paper money. The Civil War, the Union government, the federal government printed greenbacks to fund the war, and then they were declared legal tender. And states like California, who had a lot of gold because of the gold rush and had a very strong, gold-based economy, the merchants all got together and lobbied the government and were able to put these clauses in that said, we're accepting gold, and gold, we're not going to be bound to accept paper money. If it says gold, that's what it is, that I shall be paid in gold. And then they passed legislation that said, yes, if two parties agree to be paid in a type of money, the repayment has to be in that type of money. We're not going to call it satisfied, the judgment satisfied, if you use greenbacks. It's got to be in the money that was contracted for. So these gold clauses existed for a long time. And then it came to a head when FDR was confiscating everyone's gold and then, trying to push through his economic reforms. And so like the federal government had gold clauses in their bonds, and also there were these private ones. And so the government passed a law just saying like, those are invalid. Like gold clauses are invalid. You gotta pay up in paper money. You gotta accept paper money in discharge. So, all the creditors took a haircut, right? All the debtors, of course, were very happy. But these cases were like really, really big. Everyone was talking about them to the point where, and it was very, very rancorous. And this was also at a time when the Supreme Court had been, thumbing its nose at the presidency and just striking down all of FDR's New Deal plans. And it was very close to this time when he started being very aggressive in response and threatened to increase the number of justices on the court and pack the court packing scheme and all of this. But what happened with these gold clause cases is he had a speech written, a radio address, ready for when the gold clauses would have been upheld, when they thought maybe the Supreme Court was going to uphold these gold clauses against, and rule against the president and Congress. So he had this speech drafted and it leaked. and it basically said, I'm going to ignore the Supreme Court, and we're moving forward with our legislation. And that has been seen by some scholars as, this point where there was a ton of political pressure against the Supreme Court, and the Supreme Court bent to that pressure and ruled in favor of the president and the administration and invalidated the gold clauses.